Welcome to The Straight Dope, where you hear the real talk about Iowa Vice. Hey, we're back on with Carl Olsen. Carl, we were talking about a couple of things that had developed, over the last 5-10 years with Iowans for Medical Marijuana, something that you started that was essentially the end goal, I think, although you can tell me if I'm wrong, was to essentially put in place a state medical marijuana program for people with conditions that would benefit from the use of THC and other cannabinoids. Is that a fair way to?
Well, we knew that marijuana was medicine.
Now wait a minute. The federal government said marijuana is not medicine, though, right?
Well, I think the federal government has been tiptoeing around that issue forever.
That's fair.
I think that, they wouldn't have set up a research program and supplied people in Iowa with cans of 300 cigarettes a month, and if they didn't have some suspicion that it had medical use. So, yeah, it didn't have accepted medical use, but it was definitely being considered, that possibility existed. But what I'm saying is I knew it was medicine, and I wasn't the only one, and the federal government certainly had suspicions about it. So everybody was aware that there was this potential argument floating around for medical marijuana. And I knew that I needed to have a different equal protection argument than peyote.
Because collateral estoppel.
And what a better equal protection argument than my sacrament. Like, they're using my sacrament, and they're allowing people to use it for some good, noble purpose without any proven, demonstrated, absolute FDA approval that it's good for anything. And they're giving it to people who are seriously ill with horrible medical conditions, experimenting on them with my sacrament. So I saw this developing, and then, of course, when California enacted this broad law, and then other states that same year, Hawaii did it in 2000, a couple of states in 98, Washington. And so anyway, you could see this thing exploding, and in my mind, in 1990, this was going to be my equal protection argument someday. And I could see it developing, and it just has, continually, even this moment while we're sitting here. So that explains why I started Iowans for Medical Marijuana, because that's where the government was allowing this flexibility to exist.
And the end result of that advocacy effort with, having those discussions, showing the medical use of marijuana, particularly Iowans involved in a federal pilot program, you were instrumental in then, I think, encouraging a medical marijuana program.
In 2006, we decided to incorporate Iowans for Medical Marijuana, and we decided we were going to petition the Iowa Board of Pharmacy to reclassify marijuana. And the reason was because of a decision in the U.S. Supreme Court in 2006 called Gonzalez versus Oregon. And in that case, the case was about the prescription of Schedule II controlled substances to assist in suicide. Attorney General John Ashcroft said that was not a legitimate medical use and issued a rule saying that was illegal, and Oregon sued and won. So I made the argument that because Schedule I criteria says no accepted medical use in the United States, that a dozen states with statutory law saying this is medicine proves that marijuana has accepted medical use in the United States somewhere. And there was a case called Grinspoon versus DEA in 1987 where the First Circuit, U.S. Court of Appeals, actually said that the definition of in the United States means anywhere, not everywhere.
So the fact that any state approved it for medical use means it has accepted medical use.
Yeah.
Reason to take it out of Schedule I.
And in the current decision from the HHS that's under review right now, it sort of says the same thing, except for the difference is that the HHS is now saying that it took some time for those state laws to play out and accumulate enough data that it could be examined on the basis of science and not as a legal argument. So I made the legal argument because these programs hadn't been up long enough to develop data like what we're seeing now. So I confronted the Iowa Board of Pharmacy with that, and they rejected it, and Judge Novak here reversed them on some technicality where they didn't interpret the law correctly. And they were so embarrassed by that they held 4 public hearings, one in Council Bluffs, one in Des Moines, one in Mason City, and one in Iowa City, 8 hours each with a certified court reporter. I have the transcripts from all 4 of those things to determine whether marijuana had medical use as a matter of science. And because I was so connected with all these people, I got the Marijuana Policy Project come in and help me, Drug Policy Alliance, NORML, Patients Out of Time in particular, which was an organization that we all formed in 1995, a national organization. Their first conference was at the University of Iowa Medical School. Melanie Dreyer's on the board, so same Dean of Nursing I was talking about. And she testified at my trial, too. She was one of my witnesses and actually showed up in person took the witness stand in my trial. So we presented evidence from Dr. Meshulam from Israel testified, Sunil Agrawal from the University, Dr. Carter from Washington, the same people that filed the DEA scheduling petition in Washington testified here in Iowa. And after those hearings, the pharmacy board said marijuana has medical use and should be transferred to Schedule II. I filed an appeal with the Iowa Supreme Court saying, no, it's a straight-up legal argument. It doesn't have anything to do with science. And the court said, but you won. They ruled in your favor. You lost your standing. You can't appeal that. You would have to be the loser to appeal that. And you won, so you can't appeal. And so I have that in writing from the Iowa Supreme Court in 2010. And then they introduced legislation to reclassify marijuana, and the Democrats say, that's absurd, that's ridiculous, we shouldn't listen to that. And I thought, Democrats? The last people on earth I thought I'd be fighting against. So,
but eventually,
McCarthy, the son of the sheriff, Kevin McCarthy, Speaker of the House, single-handedly says, I went and talked to the pharmacy board and they say this is all bullshit. And I'm going, who'd you talk to over there? That wasn't the ruling. The ruling they made wasn't that it was ridiculous. They ruled that it was medicine and should be reclassified. So he's over there talking to their attorneys who are all disgruntled about the whole thing and saying that's the pharmacy board. So the distortion was unbelievable. But I won that, and I have legislation introduced to prove it. So don't accuse me of not trying hard.
No one's ever going to accuse you of that because your efforts bear fruit. Eventually, we get a Iowa Code Chapter 204.
Oh, that's another thing. They recommended that Iowa set up a medical marijuana program. I forgot about that. So they went beyond the Schedule II recommendation and recommended that we have a program. So in theory, I could take credit for that. Clell Bodler is the architect of the program we have now. And he attended those hearings, and when he was having his hearings on this law that we have now, he goes, hi, Carl, how you doing? So, there's a connection.
But when we could probably have a whole nother episode on what is medical cannabidiol, why it's a bit of a misnomer. Cannabidiol is one specific thing. It's not any number of cannabinoids, but we now have a system set up where
got plants growing in a greenhouse. We've got extraction going on. They can have pure THC. They make a product with 80%, a vape pen with 80% THC. We were always told you can't have marijuana because it has THC in it. It's now you can have THC, but you can't have marijuana. It's like, well, then it didn't have, THC was a...
So we've got a tightly controlled program. People with debilitating medical conditions can get a medical certification by a doctor, and then they can take that certification, apply for a card, get the card, then go to a dispensary where all of the dosing, product recommendations, all of that occurs outside the doctor's
Outside the medical system,
Outside the medical system, correct. But what that...
Conventional.
What that ends up
We would have to
doing-
say this is some kind of traditional medicine or something, or the kind of medicine we had before 100 years ago, before the modern,
Of course, yeah.
you know.
But at that point, you now have a secular use of marijuana. Before this program, Iowa could say to anybody, to you, we prohibit the use of marijuana across the board. No one can use marijuana. Not medically, you can't possess it. We have criminal sanctions. We're gonna do that for everybody. And you were kind of butting your head up against that universal prohibition, collaterally stopped from raising First Amendment religious
Now, I
freedom.
do agree that the First Amendment should be a valid defense. No
Correct.
harm, no foul actually makes sense. There's probably common law history on that. So I don't know how we've evolved into this thing where we don't recognize if there's no harm, there has to be some solution other than lock them up and throw them away.
But this is where we kind of come full circle, Mitchell County versus Zimmerman and the religious freedom arguments raised there, because once you carve out a secular exception.
Yeah. In Zimmerman, there were other people being allowed to do things that were equally damaging, and there was no reason why only religious use could not do that damage.
Correct. So
Same damage.
Talk to us about collateral estoppel and the secular use of marijuana under Iowa's medical cannabidiol program.
Well, collateral estoppel means it has to be the exact same situation.
Yes.
So obviously my argument would not have anything to do with peyote. It would be completely based on something I've never argued before.
So
marijuana,
now,
accepted secular medical marijuana. Well, I shouldn't use the word medical. Secular. It's non-prescription. I was in court Friday.
That's a better way of describing it.
I was in court on Friday, and I told the judge they have this peyote exemption and they have this crazy non-prescription cannabis program they got. And the judge looked at me and nodded, going, those are your arguments.
Whereas before, you couldn't make the argument that you had a First Amendment defense to the possession and use of cannabis because you're collaterally stopped from doing that. It's been raised and litigated against you. Now that there's a secular use in Iowa, what does that enable you to now do?
Well, it enables me to do two things. First of all, we don't know that a First Amendment claim would be rejected in Iowa, although they did adopt Smith in your Zimmerman case. So apparently they don't recognize a First Amendment standalone defense. It didn't sound like it in Zimmerman. But anyway, Zimmerman didn't have a standalone First Amendment. He had an equal protection claim.
Correct.
So I still have that. So I made an argument that the state should adopt rules last year, and that's what I'm in court on now.
So you're asking
based on the marijuana.
So because we have this now existing framework, this application process for patients to seek a medical card.
Yeah, illegally.
We have to people should realize that while it may be legal at the state level, cannabis is still, marijuana is still a Schedule I federally controlled substance.
Yeah, it's entrapment.
And so it may be legal at the state level, but and this is another part of your argument, even if you were granted a religious exception to possess and use cannabis, are you going to go out and get one of these 80% pure THC vape pens from Bud and Mary's?
Well, no, because they don't have a federal license.
Right. Explain why you need, why to make this complete, you need a federal exemption as well as a state exemption.
Well, it doesn't make sense to me that you would pass a state law making something legal that's still a federal crime, and you wouldn't be concerned about the federal criminality of it. Like, why are you concerned about the law at all? If you just want to break the law, just break the law. So the answer to that would be, well, we didn't know there was any way to reconcile this with federal drug law. So I went in and told the board that regulates the program in 2019, I said, is everything you guys are regulating here a federal crime? And they're looking at me, well, of course, like everybody, you're not supposed to say that. What do you?
Yeah, you're saying the quiet part out loud.
Yeah. And I said, well, if there was something we could do about it, well, should we? I mean, these are doctors with the Hippocratic Oath, do no harm. So I'm going, if there was a way we could reconcile this with federal drug law, should we? And they're going, well, of course. I'm going, well, there is. Peyote's reconciled under both state and federal law, no problem. They got federal and state license. And here's the application process under the federal law. Why hasn't any state filed one?
Because there is a federal process to seek an exception for.
Yeah, because it's regulatory.
Right.
21 CFR 1307.03 is the application. And for the commercial side of it, for the peyoteros, you've got 21 USC 822D, which authorizes the Attorney General to waive the registration requirements and register anybody if it's in the interest of public health and safety. And of course, these laws, the states are saying this is in the interest of public health and safety. When they enact them, that's given. There wouldn't be any explanation if the state government is saying we want to do this. It's in the interest of the public.
And so you have petitioned the state for rulemaking, administrative rules to enable you to pursue a religious exemption.
To allow
anyone
Yeah.
to
Like
allow
a vaccine
anyone.
or a mask in the pandemic, same thing.
And you've also petitioned the DEA to recognize a federal exemption for you for cannabis.
And you went with me to the meeting.
We did.
Yeah.
First time I've been.
In the DEA headquarters.
But so you're trying to, I don't know what the word would be, but you're putting all the pieces in place simultaneously so that when these go in your favor.
Well, I told the DEA that my federal exemption is conditional on getting a state exemption, and they just issued one to the Church of the Eagle and the Condor, and in there it says they have to comply with all state laws. So I'm not just imagining this, it's real.
And what does that church use as a sacrament?
Ayahuasca.
Okay, plant-derived
DMT.
controlled substance, DMT,
Yeah.
Schedule 1.
Yeah.
And so there are steps now for peyote, ayahuasca, and hopefully cannabis.
Yeah, because the ayahuasca people have an import license from Brazil, and Brazil recognizes this under their national government as a valid religion in Brazil. I'm not sure how many countries do. Peru, I think, is another one. But and Jamaica recognizes cannabis as a sacrament now since 2015, and peyote has been recognized as a sacrament all this time. And there's a place where it comes from where it's legal under national law. And in this settlement agreement with the Church of Eagle and the Condor, it contemplates them growing it here in the United States instead of importing it, saying if they want to do that, they can. They just need the necessary permits.
So the framework's in place for this.
Yeah, the framework's in place for me to grow it at my home, and there's nothing preventing a member of the Native American Church from having a peyote plant, and there's nothing in the ayahuasca thing that says that an individual of that church can't have ayahuasca. It's only if they intend to distribute it to others where these things start coming in with the regulations. And so what I'm thinking is that my tradition is not to use cannabis alone, but
if other people, members of the church, wanted to use cannabis simultaneously,
they could each get a license, and it would be like the Commission on Marijuana from 1972 under the Nixon Commission. When they put marijuana in Schedule 1, it was so controversial they had to create a presidential commission, which our governor and Senator Harold Hughes was a co-chair of. And that commission recommended that marijuana not be criminalized for personal use and possession and distribution for small or no remuneration.
and that's exactly what happened, right?
And then they rejected that, okay? But if you look at the peyote exemption, the members of that church, that's exactly how that works. They can share peyote amongst each other without getting into that commercial aspect. And the same thing with the ayahuasca church. They can share it amongst themselves. They just need the import license to get it from Brazil to the United States. Once it's in Arizona, it's up to them how to distribute it. If they want to manufacture it, now they have to have some additional permits because they're going to manufacture it for other members of the church. So I would say that homegrown is not going to be manufacturing. Two people growing homegrown saying, hey, I got a plant here, I bet it tastes better than your plant. I don't contemplate that as being regulated.
I do want to bring up one more thing.
Yeah.
the development with medical cannabidiol that enables you to then revive this argument, I think is a huge step in the direction that you're headed. But there's recent Iowa legislation, and if you can comment briefly on it, we talked about the federal Religious Freedom Restoration Act. Iowa passed a state version of that, nearly identical in scope. That's going to take effect. What will that do, if anything, to the argument?
Let me read the words of Justice Kennedy.
So you're reading from a Supreme Court opinion.
From 1997, City of Bern versus Flores.
Okay.
Justice Kennedy speaking for 6 members of the court, 6-3 decision, requiring a state. Well, first of all, the Religious Freedom Restoration Act applies to every agency and office of the state and local government. Applies to all state laws, statutory and otherwise, whether adopted before or after its enactment. Requiring a state to demonstrate a compelling interest and show that it has adopted the least restrictive means of achieving that interest is the most demanding test known to constitutional law. So it applies to every law, every regulation, every state agency. They have to accommodate religious beliefs, and they have to show that they put some effort into it. They just can't say, well, we won't accept your application.
Or we don't have authority to do the rulemaking.
So this was enacted April 2nd. I filed this case back in September last year, filed an appeal in district court in December last year, and while the case is pending, this thing gets enacted.
So it's
a month ago.
It's not going to hurt.
It adds 3 exclamation points to my argument. And it also entitles me to come back and file in district court for declaratory judgment or an injunction, which I couldn't have done without it. So now it gives me that insurance that they have to take me seriously because they're not going to get away.
And it also enables us to come back and revisit this issue, as your rulemaking case progresses and what would ever happen with an injunction or a restraining order or damages or anything like that. So the
rules is a civilized way to go about it, but it allows you to go straight into district court and just flat out ask for an injunction against the enforcement, which would be the crude way of doing it. But that's what this contemplates. They're saying, hey, we're getting sick of this. We're going to give people a way to challenge these things.
Exactly.
Yeah.
And so so I'm smiling because
they're unhappy because the governor shut down the churches and left some businesses open during the pandemic.
So a response to COVID.
Well, this got up and the movement got up and rolling before that, but that was the icing on. That took that really irritated.
That paved the way that this was going to.
Yeah, when that happened, they said, we're doing this. And I mean, this is getting to be an emergency. We can't have the governor telling us we can't go to church, but we can go to buy some stuff at the store. In California, they closed the churches and left the medical marijuana dispensaries open.
Right.
Yeah.
So as you can tell, I'm excited because I see how this can support the argument, how it can advance the argument.
Yeah.
And, like I said, 50 years, you've been making this argument. I think we can see the light at the end of the tunnel.
And I'm conversant in it. I can talk to a judge and actually.
Carl, like I said, you know more about this issue than anybody. And so I want to thank you for coming and spending the afternoon with us here today. And I look forward to having you back.
Thank you.
Thank you.